I just wanted to welcome you all to tonight's event, and it is actually our first event of the year, and we're starting obviously off with a virtual event, so hopefully we will see you all in person soon at some events. So tonight we have the Beyond the Basics Effective Enforcement Solutions event with Alex Irvine of Fraser Irvine Sheriff Officers. We will have time for a Q&A session at the end, so please do pop any questions in the chat box at all if you do have any. Likewise, the session is being recorded, so if you want to refer back to anything, it will be uploaded onto our website as well. So firstly, then we have Alex Irvine, who, like I said, is from Fraser Irvine Sheriff Officers and has been a partner of Fraser Irvine Sheriff Officers since 2017. He's also the past president of the Society of Messengers at Arms and Sheriff Officers, and is involved in the training of sheriff officers and messengers at arms. So he is really well to speak to us tonight in terms of the topics. So I'll just pass over to Alex, and like I said, pop any questions in the chat box. So thank you, Alex.
Thank you, Leila. Well, good evening, everybody. And I would say it's nice to see you all, but all I can see is names on the screen, and it is quite strange. I still find it strange anyway, doing these kind of presentations over Zoom. But it is good that we're able to connect with one another, and I'm delighted to be here tonight and to share with you a little bit about diligence and how we can use that effectively. And let me start by also saying how delighted I am to be able to partner with SYLA, and I think that the work that SYLA does is just fantastic, and these Beyond the Basic evenings, which run continually throughout the year, really are fantastic and a great way to connect. And if you're watching tonight and you've just clicked on via the Eventbrite page and you're not active in SYLA, then take the opportunity to get involved. The whole breadth of topics that gets covered and the opportunity to network and connect with one another, particularly at the start of your careers, is just a really important opportunity. As I said, I'm not used to doing these presentations over Zoom. We're at this point in the day where things are just as the sun's just starting to go down. So I've got a real glow behind me, and it's not a holy glow or anything like that. It's just the sun setting. So I'm trying not to dazzle you, but hopefully I'll dazzle you with my knowledge of diligence and enforcement. I like to move about usually when I'm speaking, and so sitting down is a real challenge as well. In fact, just in order to make sure that I didn't get up and move about, I'm not wearing any trousers, so I'm just sitting here in my pants. I'm kidding. I've got trousers on. But I'll try not to move too much, and you might see my hands flapping about and so on. Another challenge with Zoom is you don't know if anyone's laughing at your jokes and if they're rubbish or not, and perhaps that was a rubbish one. But we are going to be serious tonight as well. We are thinking about diligence. As Leila said, I'm a sheriff officer and I'm also a messenger at arms. Sheriff officers are the people who are responsible for enforcing court orders as well as citation of court documents, and throughout your career you will encounter us. A messenger at arms is simply a court officer who's qualified to serve and enforce court of session and high court process. I've been involved in this profession since I left school and worked in a variety of roles, both internally in an admin function and also externally and as a commissioned officer of the court. And it's certainly been an interesting career, and one where you encounter a whole variety of people. And no matter what route that you go down within your chosen field of practice in the law, you will probably at some point or another encounter sheriff officers and perhaps have to deal with diligence. And so I suppose the first question to answer tonight, what is diligence? Diligence is the term used collectively for the measures which are available to enforce a court decree, particularly in relation to payment of money. And it's payment of money that we'll be thinking about tonight. So let me just make sure that this screen is, there we go. So the basis for diligence, first of all, the basis for diligence, there are a whole variety of different types of orders which can be a basis for carrying out diligence. You can carry out diligence on the dependence of an action. That's a particularly limited field where you have to seek the permission of the court and have a reason to use certain diligences on dependence of an action. And we'll talk about what diligences are available there later on. The most common basis for diligence is an extract decree. That's a decree granted by the court at the successful conclusion of an action, normally in favour of the pursuer or who becomes the creditor. A decision, which is the new word which we use for simple procedure now, so a simple procedure decision is also a basis for diligence. In addition to the decree or decision of the court, you also have tribunal orders. That can be an employment tribunal, or quite common at the moment are tribunals from the first tier tribunals for Scotland and the Housing and Property Chamber. But any tribunal order generally has a provision embedded in legislation which will allow for enforcement in the same manner and fashion as a decree issued by the sheriff. And the last category mentioned at the moment is a document of debt, and certain types of documents can be registered for preservation and execution in the books of council and session or in the sheriff court books, and these documents can also be enforced in the same manner as a court decree. The most common examples of that would be a lease, for example, a commercial lease, or perhaps a minute of agreement. And these documents generally contain a clause for preservation and execution. And once registered, it will then allow you to enforce that in the same manner as a court decree. And that can be a useful and efficient and speedy tool to have at your disposal. Now, all of these documents will have, in some form or another, what we call a warrant, and it's the warrant for all lawful execution. And that is the basis which allows us then to exercise the various different diligences which are available. So your extract decree, if you've seen an extract decree, you'll notice at the bottom of it, that phrase, this extract is warrant for all lawful execution. And that really is an essential requirement in order to carry out diligence on the basis of that decree. Now, there are a number of different types of diligences which can be carried out on the basis of a decree or a document of debt. We're going to look at all of them tonight, and I'm going to highlight some of the pros and cons and how we can use them effectively to try and recover the debt that's outstanding for your client. So the warrant for all lawful execution, as I said, authorises a variety of different diligences. The authority for that is contained within Section 87 of the Debtors Scotland Act 1987. One of the helpful things, I suppose, in relation to diligence is that most of the provisions are located in one of three places: the Debtors Scotland Act 1987, the Debt Arrangement and Attachment Scotland Act 2002, and the Bankruptcy and Diligence, etc. Scotland Act 2007. These three pieces of primary legislation contain the basis for most of the diligences which we encounter and which we'll be talking about tonight. But the warrant for lawful execution is re-emphasised in Section 87. It actually comes from Section 7 of the Sheriff Court Scotland Extracts Act 1892. And you'll see on your screen here the various diligences which are authorised by that warrant for all lawful execution. So they are a charge for payment, an arrestment, an earnings arrestment, in the case of maintenance, a current maintenance arrestment, an attachment, a money attachment, and also inhibition. And as I said, tonight, what we're going to do is we're going to look at each of these in turn and draw out some of the key points and key considerations that you might have. And in addition, we'll think a wee bit about the practical use and the pros and cons of using these various diligences and when's the best time in the recovery process to deploy them. So the first one is the charge for payment, a charge for payment of money. Now, a charge for payment of money is in essence a formal written demand for payment in the name of the sovereign, which demands payment from the debtor within a specified time. It is the first step normally in the enforcement process, and it is served by hand by a sheriff officer accompanied by a witness who will attend at the debtor's dwelling place or place of business and serve the charge for payment. It is a useful first step in the process, and it allows not just that formal step in the process, but also allows, from a practical point of view, to get a real live assessment of what the prospects will be for further recovery action. Because it can also actually be one of the first times that the debtor has had some face-to-face engagement in the whole process. If you consider nowadays how much we rely upon technology, it can be easy to obtain credit, to buy things online, to fall into arrears online, and you can actually go through the whole process of getting yourself into debt without having any face-to-face contact. And so the charge for payment of money is often the first time that the debtor has actually had to speak to somebody about dealing with their debt in a real life scenario. There are a number of things that I've noted on the screen here just to highlight for you. The service of the charge, as I've mentioned, that's done by hand by a sheriff officer. It can be left at the address and it can be deposited if the debtor's not present, but it is formally delivered. We also use this as an opportunity to provide the debtor with a debt advice and information package. That's down towards the bottom of the screen, called a DIPE for short, and that's a prerequisite before carrying out some of the other diligences which we'll be thinking about. The DIPE itself signposts the debtor to debt advice, money advice, and it also highlights some of the consequences of what will happen if they don't engage in the process and work towards getting a resolution of their debts. The days of the charge, that's normally a 14-day period within which the debtor has to respond to the charge for payment. And so hopefully within that 2 weeks, the debtor will take stock and get in touch with the client or the creditor to start perhaps negotiating settlement or to make payment in full if they're in a position to do that. The charge itself lasts for 2 years. So the things which you do following on from the charge, you've got 2 years within which to do that. And at the end of that 2-year period, you can actually serve a further charge for payment as well. So it can sit there for a while and you've got a bit of scope if you're wanting to enter into discussions with the debtor about coming to some informal resolution to their situation. The charge for payment, as well as being a good first point of contact with the debtor, is also a necessary prerequisite for carrying out some of the other diligences which are available in enforcing your decree. So before you carry out an attachment or an earnings arrestment, you have to first of all serve a charge for payment of money. And so it's a necessary prerequisite. Another prerequisite that or another thing that a charge can be used for is to establish apparent insolvency, where you serve a charge for payment and the days of charge expire without payment. That establishes the debtor's apparent insolvency, and that's the status that an individual has to have in order for you to present a petition for their sequestration. There are a number of other grounds which can be used to establish apparent insolvency, but a charge for payment is certainly one of them. One thing to bear in mind, though, if you are going to use the charge to establish apparent insolvency, the charge has to have been served within 4 months of the presentation of your petition for sequestration. I've already mentioned that a second or a further charge is available, and you can use that at the end of the 2-year period. Now, you can serve a further charge before the 2 years is up, if you just perhaps as a method of re-engaging with the debtor if that's just fallen by the wayside. There is a cost implication there that you should bear in mind. If 2 years expire and you serve a further charge, the cost for the initial charge is added on to the debt. If you serve a further charge within that 2-year period, that expense is not recoverable as part of the debt. And we're going to talk a wee bit later on in the presentation just about costs and what expenses are chargeable to the debtor. So that's a kind of an overview of the charge. It's a useful way to, as I said, to start off the process, to start off engaging with the debtor if there's been a period of time where there's not been any engagement. And that can often be the case where demand letters have been issued, where court actions have been commenced, where the summons or the claim has been posted out, and all the way through that process that the debtor just doesn't engage. Often the case can be that people, when they're getting into trouble financially, it's the head in the sand mentality where they just don't want to face up to dealing with their debts. And so actually that physical visit by a sheriff officer can really pull things into focus and can start off that engagement. And as I said, it's also a very useful way of just establishing what the debtor's circumstances are. So what kind of property, what assets are apparent, if we're able to interview them to establish what their circumstances are. And when we're, as a sheriff officer, when we're serving a charge for payment, we always try and engage with the debtor and get them to engage with the creditor and try and establish what their circumstances are. Do they work? Do they have other assets? Do they have a car, for example? Are they in a position to pay the debt? What kind of property do they live in? And as a practice, we'll report back and provide details of, you know, do they stay in a house? Do they stay in a flat? What kind of area is that in? What is the property worth? And these can all inform you when you're making the decision and when you're advising your clients about the decisions about whether to incur further expense and to take further steps in enforcing your court order. So the charge, a very useful starting point in the process. The next diligence I want to mention is arrestment, sometimes known as a bank arrestment, but can cover a whole range of other organisations as well as banks. Now, you don't need to serve a charge for payment before you serve an arrestment. So you can go straight to the arrestment when you're enforcing your decree. Arrestment is basically a diligence which is served in the hands of a third party, which may have assets, movable assets belonging to the debtor. The most common example of that is a bank where the debtor will have funds in the hands of the bank, and the arrestment served in the hands of that third party freezes the assets in place with the third party until such time as they are either automatically released or followed up with an action of forthcoming, and we're going to talk about that in a few moments. As I said, the most common example of an arrestee is a bank, because that tends to be the place that a debtor would keep their funds with, and most of us have bank accounts. Arrestment is available on the dependence of an action, so if there is grounds for seeking to arrest before you actually obtain your order, you can apply to the court for an arrestment on dependence. The procedure for that's outlined in the Debtor Scotland Act 1987. It involves an application process to the court. It involves satisfying the sheriff that there are grounds for seeking an order for arrestment on the dependence, and there are some practical variations once that's granted between an arrestment on dependence and your standard arrestment and execution, as we would call it. I'm going to speak mainly about the process when you arrest in the hands of a bank, because that is the general place that you're going to go for an arrestment. There are slightly different provisions when it's assets other than money that you're arresting. An arrestment will attach both money, but also will attach any other movable items that the arrestee may have in their possession. But let's think about money first of all. In the case of an arrestment with a bank, there is a protected minimum balance that cannot be arrested, and that's basically a sum which allows the debtor to continue to live, and it's just about around £500. So they have to have in excess of the protected minimum balance in order for the arrestment to be effective. There's also provisions with an arrestment for the amount arrestable to be specified. The process basically is that when you instruct the sheriff officer to serve an arrestment, they prepare an arrestment schedule, which they will then deliver to the bank, and that arrestment schedule sets out the particulars of the court order or decree and the amount which is sought to be arrested. There are two different amounts which are on that schedule. There's a maximum amount and there's an automatic release amount. The maximum amount covers additional things like additional interest while the actual arrestment process is happening. And then there's an automatic release amount, which is the amount which will be released if the arrestment is successful in attaching the full sum that's due. When the arrestment is served with the bank, the banker is required, out with that protected minimum balance, to freeze any funds which they have in their possession belonging to the debtor. They will then, after a period of time, as long as there's not been an objection lodged by the debtor with the court, automatically release that amount to the creditor. The bank or other arrestee has a requirement in the Debtor Scotland Act 1987 to disclose what sum has been arrested within 21 days of the arrestment. Although, oddly, when the rules were being drafted, it didn't put any requirement in the bank to tell you if the arrestment was unsuccessful. So it tends to be that some banks will tell you either way. Other banks will just not contact you if the arrestment's been unsuccessful. But if there's been funds attached within 21 days, they will notify the creditor or the creditor's agent that funds have been attached and when they will be released. The automatic release then follows after 14 weeks, and the interest calculated that can be recoverable is included within that sum. And so if your arrestment's been successful, after 14 weeks, you should then obtain a payment from the bank for the sums that's been arrested. There's no limit to the amount of times that you can attempt an arrestment until your debt's extinguished. So if an arrestment only attached part of the sum that was due, you can attach a further or try attempt a further arrestment as well. Now, on the screen there, you'll see that subjects arrestable. There are a range of different subjects which can be attached by an arrestment. Money is the main one, but there are other subjects which are arrestable as well, including corporeal movable properties. The basic rule of thumb is that the arrestee has to have an obligation to account to the debtor for those assets. Where it's not money that's been arrested, it's other movable property, then the automatic release provisions which we've talked about don't apply, and you have to, in that instance, commence a further action in the court called an action of forthcoming. And that action of forthcoming is basically asking the court to order the arrestee to make forthcoming to the creditor whatever asset's been arrested. As I said, by and large, forthcoming is not used very much nowadays because most arrestments are directed at banks and they're directed at attaching funds that the bank might have. The other thing that I'd really like to highlight in terms of, well, in fact, before I get to that, let me tell you how long an arrestment lasts for. The arrestment itself is effective for a period of 3 years from the date of arrestment, and that really only comes into play when you've arrested items other than money, because you've got that automatic release for funds after 14 weeks. When to use arrestment, that's a really important thing to highlight. And when to use an arrestment, if you instruct a sheriff officer to serve an arrestment and tell them where you want the arrestment to be served, the sheriff officer will go and serve the arrestment. But this is one of these things that is worth thinking about when you want an arrestment to be served, because the key element of the arrestment is that the obligation to account has to exist at the time of the arrestment. So if you serve an arrestment today, for example, in the hands of the third party, in the hands of the bank, the arrestment will affect or attach what's in the hands of the bank just now. So if there is no money in the bank just now, the arrestment's ineffective, irrespective of the fact that there might be money going into the bank 2 days from now into the debtor's account. So it's only what's there at the time of the arrestment that can be affected by the arrestment. So you should think carefully about when you want an arrestment served, and that will be determined as much by what you might know about the circumstances of the debtor that you're pursuing. But a few general rules of thumb: if you're pursuing an individual, think about when you've got money in your bank account to have the maximum effect. Generally, most of us get paid towards the end of the month, so lodging your arrestment round about the end or the beginning of the month on an individual is probably a good rule of thumb. Similarly, in cases of businesses, perhaps towards the middle of the month might be a useful point as well. So think carefully about when to use your arrestment. And another thing just to bear in mind, and this is for earlier on in the process when you're having that initial engagement with your client, who's perhaps wanting you to raise the action against the debtor, is to try and gain as much information as possible. Does the client know where the debtor banks, for example? Have they had a bounce check before? So gaining that kind of intelligence early on in the process is quite useful as well. Now, there are some questions coming up in the chat, so I'm going to just see if we can maybe just look at some of them just now. So somebody's asked, is it possible to provide information on cost of enforcement action? Okay, we'll come back to that when we're perhaps at the
Sorry,
at the
Alex, to
cost
interrupt.
section.
Just to let you know, I think that first couple of questions are the ones I actually emailed you about anyway. So I think you're already covering those off. So
Okay.
you're that efficient.
Somebody has asked, what kind of reasons can be put forward for an arrestment on dependence? Does this work for employment tribunals too? It doesn't work for employment tribunals. Arrestment on dependence is only available in court actions. It's outlined in Part 1 of the Debtors Scotland Act 1987, the actual application process, Section 15, I think it is, off the top of my head, that the reason that you have to convince the sheriff of is that if you don't get your order, there's a threat that the debtor will move their assets beyond the reach of the court, or that they're approaching insolvency. So that's the two main reasons that are generally used for seeking an arrestment on dependence. Another question that's been asked is, how is the arrestment of movable property assessed? For example, how would the sheriff officer know that the value of the asset is not more than the debt? Say we are talking about a vehicle. In terms of movable property, if we move away from the example of a bank and say it's a different kind of company, a different kind of third party, the arrestment basically orders that third party to arrest any funds up to the value of the debt that they have and any movable property. So all movable property is arrested if there isn't funds available to cover the debt. So if the automatic amount of money is arrested, then it wouldn't affect movable property. But if the third party doesn't have any funds, or there's not enough funds to cover the maximum amount arrested, then all movable property would then be arrested, and that's then where you then have to go to your action of first coming for the court to determine what items should be then released in any assessment that would be made by that. But the whole amount would be, or all assets would be affected by the arrestment, and it would be then for the sheriff to determine at a later date. And obviously that can be a useful leverage for the debtor to then actually just contact you and to make an arrangement to pay the amount and have the assets released from the arrestment. So as I said, it's not that common to get circumstances like that, but it can be, particularly in commercial situations, a useful tool from that respect. I think that is all the questions I can see popping up at the moment. So we'll move on, but please keep putting your questions in, and when we see them, we'll try and answer them. I'm conscious I'm running. We're rapidly running out of time. I don't want to keep people from their dinner, and we've only covered a couple of things. So I'm going to try and race through the next few. So if there are questions coming up, we'll pick up on them certainly at some point. I'm certainly not in any rush to get off. But the next diligence is earnings arrestment. An earnings arrestment is a diligence which is served in the hands of a debtor's employer, and it is basically an order for the employer to make deductions from the debtor's salary every payday until the debt is paid. This is a a diligence which takes a long time to work its way through. It's outlined in Part 3 of the Debtors Scotland Act 1987, but the basic effect of the arrestment is it orders the employer to make those deductions. Now, prior steps before the earnings arrestment, you have to have served a charge for payment first of all. You also have to have provided the debtor no earlier than or within 12 weeks of serving the earnings arrestment a debt advice and information pack. As I mentioned earlier, we tend to do that when we're serving the charge for payment, so that's already in place. The employer is obliged to make these deductions once they have the earnings arrestment served on them. The amount that's deducted from the debtor's salary is based on a sliding scale, which is determined by their salary. So the more that you earn, the more money will get taken off towards repaying the debt. But there is also a minimum amount. So if somebody's not reaching that, the employer's not required to make any deductions. If the employer doesn't obey the earnings arrestment, then you can actually take action against the employer. You can make an application in the court and have an order granted against the employer, and you can pursue the employer for the amount that they should have deducted from the debtor's earnings. Now, the main stumbling block in an earnings arrestment is that you need to know where the debtor is employed, so who their employer is. But this is a particularly effective and well-used diligence. You don't get your money overnight, but if the person's in employment and the earnings arrestment's in place, then it means that you're going to get your payment over time, every time that the person gets paid. The employers get additional responsibilities as well as making the deductions from the debtor's salary, as is the creditor as well. And that's just basically around reconciling the amount that's outstanding. So the employer will periodically, quarterly, advise the creditor of how much is still, how much they've deducted, and the creditor likewise has to advise the employer what the current state of the debt is. Because there could be instances where the debtor might make additional payments which will affect the amount that's outstanding. The employer also has a responsibility that if the debtor leaves their employment and they know where they've gone, to make an additional, to advise the creditor of where they've moved to. There's also a requirement in the Act for the debtor to do that, although I can't say that I've ever experienced a scenario where the debtor has actually done that. So a very effective tool as long as the person's in employment, and as I said, it can last a long time, but once it's in effect, it should continue to run. That's a whistle stop tour. Somebody's actually asked the question: what happens if the debtor moves to a new employer? So hopefully I've answered that question. And most employers are fairly compliant with an earnings arrestment. Large employers in particular will be well versed in what their obligations are in terms of an earnings arrestment. We'll move on to a current maintenance arrestment. Current maintenance arrestment is it's very similar to an earnings arrestment. It's just simply what's used when you're trying to recover maintenance. So its scope's limited to cases where it's a maintenance debt for a maintenance order for the upkeep of a child. There are certain steps that you have to take before you carry out a current maintenance arrestment. You have to intimate the order to the debtor with a Form 37. Again, this is outlined in the Debtors Scotland Act 1987. The effect of the current maintenance arrestment is that the maintenance is deducted from the debtor's salary every payday, and will get paid to the creditor. This is for current maintenance. There can also be arrears of maintenance, and you can pursue the arrears of maintenance at the same time as your current maintenance harassment. And you can have an earnings harassment to recover arrears of maintenance running concurrently with your current maintenance harassment. Now, when and how to use it, there are a number of steps that you need to take. My advice always to a client is that if you've got arrears of maintenance, the best thing to do is to get the current maintenance harassment in place first of all. So intimating the Form 37 to the debtor, and there's a 4-week period that then must lapse, and there must be arrears existing, and then you lodge your current maintenance harassment. Once that's in place, we would then recommend you serve a charge for payment for the arrears of maintenance which is accrued, and in expiry of the period for the charge, the 14 days, then lodge an earnings harassment for those arrears. That earnings harassment can also capture the costs for the current maintenance harassment, and then at that point you won't have any more arrears occurring because you've got your maintenance harassment in place, and the two things will run in tandem till the arrears are paid off, and the current maintenance harassment will remain in place till such time as the maintenance is no longer applicable or the debtor ceases to be employed. So maintenance harassments and earnings harassments, very, very similar, and are both useful ways to recover your debt. I'm going to march on now onto attachment. Attachment is a diligence which is used against movable property in the debtor's possession. The most common example of that would be something like a car. There are prior steps required to an attachment. So this is one of these diligences where a charge for payment has to be served first of all. Again, as I mentioned before, the charge for payment can be a useful indicator if there are any attachable assets that the debtor might have. There are restrictions. And you also have to provide a debt advice and information package no earlier than 12 weeks before doing your attachment. There are certain restrictions on what items are attachable. So attachment is not available for items within a dwelling house. It's a separate process called an exceptional attachment order in that instance. And there's a separate application process which you have to go through in order to obtain an exceptional attachment order. And in terms of individuals, the only other attachable asset that they do tend to have are vehicles, such as a car. And there are things to bear in mind, such as whether that car is actually owned by the debtor. But in relation to commercial debtors, companies and stuff like that, you can attach items within their premises. Attachments have to be executed at certain times, so generally between the hours of 8 AM and 8 PM, and not on a holiday or on a Sunday. You can execute an attachment out with those hours if you seek permission from the court first of all, and there might be instances where that would be applicable. The officer has powers of entry when executing an attachment, so they can force entry to premises in order to attach items. Generally speaking, the process that's involved in carrying out an attachment, we'll use an example of a bar or something like that. The officer can attend at the premises, as I said, if necessary, force entry to the premises, and then attach any items which are in there which are not exempt. The kind of things which are exempt are tools of trade up to the value of £1,000, a motor vehicle which is reasonably required by the debtor, up to the value of £3,000. So items which are not exempt from attachment can then be attached. The officer attends at the premises, advises the debtor of their rights, inquires as to the ownership of the items, and then will proceed to list any items that they're going to attach on an attachment schedule. So at this point in the process, goods aren't taken away. So I know you see some of these programmes in the television of the bailiffs in England. It's not a case that two big burly guys go in and start lifting tellies out of properties. It tends to be in commercial premises. The items are listed and they're appraised at a value which they're likely to fetch on the open market. If the nature of the items require a professional valuer, then that can be obtained as well. Once the items are listed and valued, the attachment schedule is then delivered to the debtor, and the goods are then attached. The debtor then cannot dispose of those items, and if they were to do that, they would be in breach of attachment. The next step after that is the removal and auction of goods. But before that happens, the attachment has to be reported to the court within 14 days, and the debtor has a 14-day period within which to object to the attachment, or indeed to redeem the attached items. This redemption process is paying the appraised value to the officer to release the goods from the attachment. If you want to attach in a dwelling house, you have to, as I said, go through an additional process called an application for an exceptional attachment order, and the sheriff has to grant that additional exceptional attachment order. The process thereafter is similar to attachment, but there are a whole range of items which are exempt from an exceptional attachment as well. So you have to leave things like sufficient seating, so you have to leave televisions unless there are more than one. Things like tumble dryers, dishwashers, microwaves, ovens are all exempt from exceptional attachment. So if you're looking at doing an attachment in a dwelling house, an exceptional attachment, there really has to be additional items of value within there to make it worthwhile. So in the case of an individual, the asset that you're probably looking at to use the attachment process for is a motor vehicle, and the key consideration there is, is that motor vehicle owned by the debtor, and is it free from finance? And we've got mechanisms by which we can find that information out before attaching the item. One of the key things which I've noted here is managing expectations, and it's important to manage your client's expectations with attachment, because of the restrictions on what can be attached and what assets a debtor might likely own themselves and have in their possession. I've already alluded to some of the television programmes, Can't Pay, Take It Away, and things like that, which you see and really don't bear any recognition to what happens in day-to-day practice here in Scotland. So attachment, if there are items generally in a commercial setting that are free of finance, can be a useful tool, but it is by no means the most popular tool that's used in Scotland, because of the number of items which are restricted and exempt from attachment. Attachment is available on dependence. It's called an interim attachment, and like in an arrestment on dependence, there's an application process which you go through for that. It is very rarely used, and there are very few circumstances within which it's a worthwhile exercise, because the goods remain in the hands of the debtor, and you still have to, at the point of obtaining your decree, go through the actual attachment process, which is different from an arrestment on dependence. If you've done an arrestment on dependence before obtaining decree, your arrestment changes from being an arrestment on dependence to an arrestment on execution. That doesn't happen with an interim attachment. So there are very few instances where that's used by creditors. I'm going to race on though, because I'm watching my clock here, and I know that you'll have other things to do. Money attachment sounds absolutely fantastic. It's another tool in the armory. A money attachment basically allows you to go and attach money in the hands of the debtor. So you attach the money and you take it away. There are prior steps required, so you have to serve a charge for payment and provide a debt advice and information pack. This is only available in commercial premises, and so there are relatively limited circumstances where you would actually use money attachment. I've mentioned the definition of money on your slide because it covers things like checks as well as actual cash. This is the kind of diligence which can be used in a commercial premises where there is likely to be money on the premises. There has to be a decent amount of money to make it actually viable for you, though, to do that. Some of the challenges nowadays is that commercial premises, don't actually have that much cash on the premises. The last the money attachment that I attempted was in a hairdresser's, and they only had a small float of money, which was actually less than it was going to cost the client for me to execute the money attachment. So you have to think about when it's going to be applicable, and again, I put managing expectations there for your client, because not that many places are cash rich when you're going to do it. There are again restrictions when attachment can be executed, and that's 8 AM to 8 PM. You can apply for orders out with those times. We have the same powers of entry as we do in an attachment, so we can force entry to the premises in order to carry out a money attachment. We can't search people though, so the canny debtor could simply take all the money out the till and put it in their pockets when they saw the sheriff officers coming in. But we can break into things like safes if necessary to look for money. After the money's attached, there's a further process. It has to be reported to the court within 14 days, and within 14 days of the report of money attachment, there has to be an application for a payment order. And once the court grants the payment order, and only at that point can the sheriff officer then give the money to the creditor. So that's a kind of whistle-stop tour of money attachment. Again, it's not a widely used diligence, because the circumstances when it's likely to be effective are fairly limited. So places like bars and clubs might be circumstances where you might consider using money attachment, because they will be cash-rich businesses where there's a lot of money going through the till. But again, you need to think about when you're going to use it and when it's going to be most effective, and that might involve a bit of pre-planning beforehand. So if you were going to do a money attachment in a bar or a club, the normal times when you're allowed to execute the attachment between 8 AM and 8 PM are not necessarily going to be the times when there's going to be the most amount of money in the property. So it might be a case that you would have to seek the permission to execute it out with those hours, and there might be a wee bit of risk assessment and stuff like that involved in planning for that. So it's definitely available, but the scope for using it tends to be quite limited. The last diligence that I want to highlight tonight is inhibition. Now, inhibition is an order from the court which prevents a debtor from selling, disposing, or burdening their heritable property to the prejudice of the creditor. It doesn't transfer any right to that property, but it does stop them from disposing of it. So it can be a useful tool, and again, bringing the debtor to the table. Once it's served, the inhibition's registered with the keeper of the registers of inhibitions and adjudications, and effectively would stop that debtor from then selling their house or any other heritable property that they have, or borrowing against it. And so that can be protect your position, particularly if you were thinking about later on going down the sequestration route. But it doesn't carry any right to that heritable property at that point. But it can be a very useful bargaining chip when you're trying to bring and create some engagement with the debtor, and it can be used at any point in the process. An inhibition lasts for 5 years as well, so even if there isn't an immediate prospect of recovery, but there is a heritable property and there's perhaps some equity within it, it can be worthwhile putting an inhibition in place to protect your client's position. Inhibition, like arrestment, is available on dependence, and again, there's an application process that you can go through to use that. Again, just trying to rattle through things here just now. Diligence stoppers. What things can stop you from doing and prevent your diligence? Recall and reponing. Where a decree is granted in absence, there is a right of recall. And if a decree is recalled to the court, a reponing note is lodged, that would prevent you from carrying out diligence, and it might recall any diligence in effect until the matter is disposed of by the court. Time to pay. The Debtor Scotland Act allows for both before a decree is granted, the debtor to apply for a time to pay direction, and post decree to apply for a time to pay order. If a direction or order is in effect, that prevents you from initiating any of the diligence we've mentioned, with the exception of an inhibition. So you can still lodge an inhibition in that instance. Moratorium. The Bankruptcy Scotland Act 2016 introduced debtor moratoriums. A debtor can apply for a moratorium, and while a moratorium is in effect, that prevents you from carrying out any of the diligences which we've discussed tonight while that moratorium is in effect. Normally, the moratorium period is 6 weeks, and that moratorium is to allow the debtor to take advice, to consider whether they want to go down the insolvency route, personal insolvency, bankruptcy, and give them some breathing space. There's been a similar process introduced recently in England. One of the consequences of the COVID pandemic has been that the moratorium period is currently extended from 6 weeks to 6 months. So if a debtor has a moratorium in effect, you can't take any steps to enforce your decree for a 6-month period, and it can also be renewed. That's one of the steps which the government are considering extending. There's a consultation out at the moment about the COVID protections which have been put in place, and it's worth you exploring that and contributing to that, because they are looking at some of the COVID things which were introduced, some of the temporary measures, and making some of them permanent, or and modifying them in some way. Certainly the moratorium, I think it's useful that there is that breathing space for debtors, but 6 months on an ongoing basis would seem quite excessive. And the other diligence stopper is if somebody goes into an insolvency situation, so if somebody's sequestrated, or in the case of a company, if the company's liquidated, that would then stop the enforcement of the decree. Costs and expenses that are chargeable. Generally speaking, the costs of diligence are chargeable to the debtor. That general, if it's successful, is the case. So if your diligence has been successful, the expense of that diligence is added on to the debt that's recoverable from the debtor. If your diligence is unsuccessful, though, that's generally not a recoverable expense. So that's worth considering before you take the step of instructing a diligence. An example would be an arrestment. You can arrest as many times as you like, but only if your arrestment's been successful will you be able to recover the expense of that arrestment from the diligence. The other thing to highlight is that the expense of a particular diligence is generally only recoverable by that diligence. So if you do an attachment, the expenses of the attachment are recoverable through the attachment process, but not the expenses of an arrestment that you might have tried independently. Again, I'm rushing through these things, guys. The main provisions for that I've listed on the screen there are found in the Debtors Scotland Act and found within the Debt Arrangement and Attachment Scotland Act. Another important point to make is ascription, and that is just how payments are ascribed to the debt. And basically, if you think about a debt, you've got your principal sum, you've got your court expenses, you've got your interest, you've then got the diligence expenses, so the expenses of a charge for payment of an earnings arrestment. If a payment's then made by the debtor, that payment's ascribed in reverse order. So the expense of the diligence comes off, the expense of any previous steps in the diligence, the expense of the interest, the court expenses, which then leaves you with the principal sum, and that has an impact on how you calculate interest that's recoverable as well. It can be quite hard for the debtor to understand that. A long time ago, I used to be involved in the recovery of parking tickets. Always something that would upset a debtor, and so they would have incurred their parking ticket, and then they would incur the expense of a charge for payment, and they would make the payment for the actual parking ticket. They would phone up and say, "I'm not paying your charge fee," and you would try and explain to them that although the sum you paid was the equivalent of the parking ticket, you've actually paid the charge fee first, and what's left is the rump of the principal sum. So that's just a useful thing to highlight. What remains for the future? The Bankruptcy and Diligence, etc. Scotland Act 2007, which is a long time ago now, introduced some new diligences which still haven't been introduced. Information disclosure orders. This would be a really useful tool. There are plans for this to be introduced at some point, although whether that will be in the life of the next Parliament, I'm not sure. An information disclosure order would allow you to apply to places like HMRC for information about the debtor, whether, so information, PAYE information about who they're employed by. That would be a really useful tool. It's not available yet. Residual attachment is also something which the 2007 Act has introduced but has not been implemented, and a residual attachment would allow you to strike items which are not covered by other forms of attachment. So things like intellectual property rights. Again, this is something which has not been introduced as of yet. The AIB, which is the government agency responsible for review and diligence, is hoping to introduce these things in the future. I think the pressures of parliamentary time and so on, though, will be a big factor on when we're likely to see these things. I'm sorry, I've rushed through these last few slides just because I'm conscious that we're now over time. I'm happy to take any questions though that you might have. So please, if you've got questions, put them in the chat, or you can unmute yourself and ask them. And Layla will keep us right, I'm sure. We'll stop talking for a minute. Take a breath.
Thank you, Alex. Let me just check if we have any further questions come in or anything you haven't covered, but I think you have. Yep, I think that's everything covered so far, unless anyone is frantically typing in the background. Hopefully not. If anyone does have any other questions, I'm sure, Alex, you wouldn't mind if, you know, I perhaps passed on your details or anything. Is that okay, Alex?
Absolutely, yeah. Absolutely.
Perfect. Lovely. And thank you so much to Alex actually for going through all of that. I realised it was a lot of things to ask you to cover perhaps within an hour, which is quite tight, and quite interesting to learn about the future kind of options as well. Actually, I think that information disclosure order will actually provide really useful for hopefully successful diligence. But I also just wanted to add as well that we do actually have an upcoming event with Alex and Fraser Irvine Sheriff Officers, a launch party in-person event, which is quite exciting and probably one of the first to take place, and that is on Wednesday the 22nd of September. I think there are perhaps a couple of places left, so if you do want to sign up for that, I will get in there quickly. And again, thank you very much to Fraser Irvine Sheriff Officers for their ongoing support over the last few years, but also this year in particular, for sponsoring our Zoom platform, as we wouldn't have been able to deliver any events at all without that support. And I hope that you realise how grateful we are for that, Alex. Perfect. So thank you everyone for attending, and we hope to see you soon. Thanks, Alex. Bye.
You're very welcome. Thanks, everyone.